Hi everyone, Zalna here. Access to finance and credit in South Africa has become more and more crucial if one wants to start a business, buy a car or a home. It's almost impossible to put these things in place without having finance or credit. The cost of living in South Africa is also high, so many people use credit to buy food. Being indebted has therefore become the norm for many of us. Anyone providing loans, finance, or credit are going to do that on their terms. There is something in the law of contract known as pactu sunt servanda, which states that the obligations created in terms of an agreement must be honored. Therefore, parties who enter into contractual agreements with the relevant intentions are obliged to respect that agreement. So whether you had the opportunity to negotiate the terms and conditions of that agreement, it's not really relevant because you had a choice whether to enter into that agreement or not. What happens when things go wrong and you can no longer pay the installments to that debt? The creditor will most likely obtain judgment against you and have you listed as a bad debtor, etc. But the question I want to explore today is how far can interest run on a debt that cannot be paid or has not been paid? There are mechanisms in law that protect the debtor, such as what is known as the Duplum rule. The principle comes from Roman law and it was later adopted in Roman Dutch law, which means it forms part of South African law. So this common law rule is based on public policy and it aims to prevent debtors from being overexploited by their creditors. And this is done through placing limits on the interest that can accrue on a debt, thus not allowing interest to run perpetually. Here are some of the elements to this rule. Duplum in Latin means double. The rule does not allow interest to run above the principal amount of the debt. For example, if your debt is 100 Rand, interest cannot be more than 100. Secondly, let's say the interest runs to the 100 Rand and the total debt with the interest is 200 and you pay 50 Rand. Interest can then again run until it reaches 200 Rand. The Duplum rule only pertains to interest and not other costs or fees that you and the creditor may have agreed to. Fourthly, a debtor cannot waive this rule in a contract, so the rule cannot be excluded through a contractual clause. So how have the courts interpreted this rule? In 1998, the Supreme Court of Appeal made a ruling that the Duplum rule is suspended when a creditor applies to court for judgment or any other litigation. That means that the interest could run beyond double the capital amount during this litigation. However, a constitutional court case in 2019 overruled that Supreme Court judgment and found that the Supreme Court of Appeal, incorrectly interpreted the Duplum rule to say that it is suspended during legal proceedings or litigation relating to the loan or credit agreement. The Constitutional Court therefore changed the position. The Duplum rule now applies even when there is legal proceedings that is instituted. So this means that interest cannot run beyond double the amount of the principal debt during the litigation proceedings. In my next video, I want to talk about the statutory Duplum rule provided for in the National Credit Act. Bye for now.